versus Zimmerman. Case number 1083. Mr. Potts wanted to appear by phone, so should we take that one up first?
It's fine with the state, right?
Yes, sir.
Okay, I have his phone number here. I'm working with him on the line. Good morning.
Good morning.
Mr. Ponce?
Yes, ma'am.
Oh, hi, this is Judge Nelson. We're all here in the courtroom, and we decided that we would go ahead and take the motion that you wanted to appear on first. This is the motion regarding confidentiality of witnesses. And everybody appears to be here in the courtroom. Mr. Romero, it's your motion.
Thank you, Your Honor. And I don't know if the court has seen the notice of appearance filed, I think, this morning by Mr. Nielsen.
No, I have not.
Good morning, Your Honor.
And Mr. Nielsen, you open the appearance of record for the anonymous witness?
Yes, ma'am. There's three that I'm here to represent their interests, and they are anonymous at this time. Okay, thank you, Your Honor.
Thank you. Your Honor, as background, there was some correspondence forwarded by one of the witnesses, and as referenced in the motion, a very significant witness, in that witness is actually an eyewitness to the altercation. So that was his testimony, and his full, complete, and unbiased testimony is going to be very, very relevant in the case. We have in place, and we normally have in place, good security and ways to handle witnesses. And when you come before an open court, you come before an open court. The concern, I'm not going to belabor the point that I've said many, many times in different contexts, most particularly in context of the motion for maintaining the anonymity of the jury. It's just that this now seems to have spilled over to the witnesses themselves. Again, as mentioned in the anonymous jury argument, it is normally, and it is appropriately, the defendant's right to proper and full confrontation of witnesses. I don't believe that confrontation applies under the Sixth Amendment to anybody else but a criminal defendant, and to the extent necessary to assure that the witnesses are willing to testify properly without concern for ridicule, retribution, or whatever else it might be that may come out of the result of this trial, that Mr. Zimmerman affirmatively waives that right and suggests that a procedure that this very courthouse, Judge McIntosh in the Hathaway case, similar in that there was a witness that had great concerns about maintaining anonymity, and in that case the process or procedure was put in place where that witness would be available for review of the parties, but not of the general public and not of the media. There are many cases that address the court's certain discretion to address these issues and to properly resolve them. Since, of course, that happened, then there are now two other witnesses who have evidenced a similar concern. If I may, knowing the case as I do, I think that there are a very few number of witnesses who would be in this category. I of course, hesitate, and I will not reach out to others to ask because I think that's very problematic. But I think that the parties would probably agree, if we had an opportunity to do so in camera or literally at the bench, that there are, in addition to the three identified, maybe 3 or 4 others who fit this category. And the category is that they are not known yet and have not put themselves out in public. That was a threshold requirement that Judge Lester put in. If you talk to the media, you're not protected. they meet that criteria. They meet the criteria as well as they're going to have testimony that is going to have impact on the jury's decision. And I mean by that, they're not just records custodians or incidental witnesses. These are witnesses who have relevant, substantial testimony to offer to the jury. And at least 3 out of these 6, well, actually another one that we know of because of the person's statements in deposition, have concerns, do not want to be involved in the case, and want their anonymity protected. So while I am sensitive to the caution that the court has to have that we need to keep control and not simply let an unwarranted concern rule the way the trial is held, on the other hand, if there are warranted concerns, if they're limited in number, and if we can put a procedure in place such as a screen literally in front of the witness so that the parties would have access but not the media or the public, then I think we've accomplished what we really should. Not to jump up on a podium soapbox as I on occasion do. We really need to make sure that not only that my client gets a fair trial, but also that the process itself is protected greatly, particularly with a review that this case is under from the public. And I think in this way, protecting the nuances of the witnesses as best we can will still guarantee a fair trial, though it is a restriction on the media's right, and I understand that. And therefore on the public's right to a certain extent, if you really, I would suggest, if you do a balancing of protecting my client's right to a fair trial, the process is right to make sure that these witnesses don't come before the jury and hesitate, limit, or in any form or fashion believe because of the retribution or whatever may happen to them in the future, impact on their testimony other than being full, complete testimony, then we've really affected the process. And the very
I understand your argument, and just to keep it, we have a lot of people who probably want to talk about it. But
I understand, Your Honor, but again, realizing that it's my client's right above and beyond everybody else, including the media, I want to make sure that his position is fully thought out, that we have nothing but full and complete testimony from these witnesses.
Judge, I would like to just add a little bit, if I could, Your Honor. I move on behalf of my clients to adopt the written motion filed by Mr. O'Mara as well as his arguments, and we do want to make sure it's clear to the court that the witnesses do want to participate. It's not that they don't want to, and they have, as recently as I understand it, yesterday, met with the state attorney's office. The problem is, of course, what Mr. O'Mara's outlined, the safety, privacy, and other issues. And, obviously we believe that between now and the time of their testimony, there could be some type of procedure that both sides could agree on that would provide the results that Mr. O'Mara's outlined for his client, as well as the witnesses that I'm here to represent. And, Your Honor, I didn't know if at some point, if you wanted me to approach, I would perhaps like to name them under seal, just so the record's clear as to exactly who I'm here on behalf of.
Did you already indicate that to the state?
I did, Your Honor.
Okay. And at some time, if you want to put it in writing and hand it up to me, and I'll know who you're talking about.
Okay. All right, Your Honor. All right. Thank you very much.
Ms. Fugate, would you like to be heard?
Yes, Your Honor. Thank you, Your Honor. I'm here on behalf of the Orlando Sentinel today, and I apologize for not filing a formal brief, but the motion was under seal, so until I got here today, I wasn't exactly sure the relief or the procedures that the defense was requesting, and still don't quite know my client's position on all of these, because this is really the first that we knew of precisely what they were asking for to maintain these witnesses' anonymity. But a basic proposition in our courts is that it's not a private proceeding. It's public property. And what goes on in a courtroom is open to the public, and it is the public's property. Witnesses don't get to come to court and testify anonymously unless there are very compelling reasons for a witness to do so. Sometimes restrictions on a ban on photography of a specific witness if there's a juvenile and it's a sexual assault, or if there's an overriding interest. And I think Your Honor is now very familiar with the post-Newsweek standard on when you can limit photography. And you have to show that there would be a qualitatively different effect on that particular witness that would be separate from other witnesses in the case. And I think it's a bit troubling, the notion that the parties could simply agree on measures that would trump and restrict the public's right of access to these proceedings and to know the evidence and the witnesses that are testifying. It's a public proceeding. The parties can't simply agree to cut off that public access. There are very high standards for doing that, and I don't think they've been met in this case. If it's to ban photography or limit photography in the courtroom, it has to be the post-Newsweek standard. If we're talking about closing proceedings, it's the standard of Miami Herald Publishing Company versus Lewis. I don't think that any of those standards have been met. It's not simply a balancing of fair trial rights. In the Lewis standard, it's that that the defendant could not receive a fair trial, despite all these other alternatives. I don't think that's been met. I'm not sure if the defense is actually asking for the courtroom to be closed or simply restrictions on photography. But even the restrictions on photography has an evidentiary standard that has to be met. I don't think that's been met. I haven't heard anything today that's been met. I can understand why some witnesses may want to remain anonymous, but when you come to a case like this, that simply isn't their choice. This is a very high-profile case, and in these cases, especially with crucial witnesses, transparency is all the more important. In the post-Newsweek case, the Florida Supreme Court went on at great length about how transparency enhances the judicial process. It enhances and aids honesty. If a witness is going to get up there, they might be more reluctant to lie on the stand if they know that people will know who they are. That you can go and check that. Transparency generally, it's not a detriment to the process. It aids the process. And I think this flips it on its head and assumes that knowing these people's identity is going to be a detriment and hinder these people from testifying. Okay. And Your Honor, if you could, we certainly would appreciate the opportunity to submit some case law to you in any briefing now that we know specifically what the defense is requesting. But I think it's essentially the post-Newsweek standard that you're now familiar with after the last case. But if you would like some additional briefing, we'd be happy to do that.
Thank you very much.
Thank you.
Mr. Ponce, do you have anything you would like to add to the argument?
Yes, and not a lot, Your Honor. I want to read what the Florida Supreme Court wrote in State versus Green, which is reported at 395 Southern 2nd 532, because it speaks to exactly what we're talking about here. And I quote, "We realize that courtrooms are intimidating and that apprehension accompanies most individuals who must participate in a court proceeding. This, however, is not a product of electronic media's presence. Courtrooms were intimidating long before the advent of electronic media. Trials with considerable public interest have always resulted in courtrooms full of spectators, news reporters, and sketch artists, all of whom add to the intimidation of the courtroom atmosphere. In our view, the single addition of the camera in the courtroom in these circumstances should not increase tension significantly, given the fact that the electronic media will report the proceedings whether or not its camera is actually in the courtroom." Your Honor, I've looked and I've not found any decision anywhere saying that you can put a screen or some other physical barrier in a courtroom to obscure a witness from view. And I've looked and I've not found any.
Well,
The Florida Supreme... Yes, Your Honor.
I just wanted to tell you, because Mr. O'Mara had mentioned the State versus Hathaway case that happened here in this courthouse. There was a motion, the witness was protected in the Federal Witness Security Program. The director of the United States Marshal Service came in, and there was a hearing conducted on the state's motion to keep the identity confidential. And the Supreme Court pointed out in the case of Waller, W-A-L-L-E-R versus Georgia, and that's at 467 U.S. 39, 1984 case, that set forth the test that was to be used in order to protect the government's interest in inhibiting disclosure of sensitive information. And it's after that hearing on that test that the motion was granted for that particular witness only. Go ahead. I didn't mean to.
No, that's perfect. That actually segues to two places I wanted to take you to. The first is that, as Your Honor said, and the Supreme Court has said this in Chavez, even where we're just talking about not photographing a trial participant, in this case a witness, there has to be an evidentiary hearing. And Your Honor has mentioned in the Waller case, I lost the title, but the head of the service came in to talk about the government's interest in maintaining the anonymity of that particular witness. And we don't have that here. As Ms. Duque said, there's been no proper evidence of how media coverage or electronic media coverage of this witness will be different than anyone else who might have to come to this courtroom. And the second point Your Honor made, and it's highlighted in Waller, is that the Florida Supreme Court in the post-Newsweek decisions that Mr. O'Mara mentioned set out categories of witnesses who are among the type who might be eligible for an order saying that you can't photograph them. And the categories that they set out, and again, the court says this isn't an exhaustive list, but it's illustrative. The list includes prisoners, confidential informants, child witnesses, sexual battery victims, witnesses under protection of a witness-type relocation program. We don't have that here. We don't have that here. I don't know if regular or normal is the right word, but we don't, as Mr. Duque said, we don't allow witnesses anonymity. We don't do secret witnesses in this country. That's certainly not on the record before you. That this witness can't be photographed. That some screen should be put up on a Hadaway case. I don't know who that witness was. I don't know what they argued. I don't know whether an appellate court approved it. I don't know anything about the Hadaway case. But I don't think on the record before you there's any basis for the entry of an order putting up a screen. I don't think there's any basis for the entry of an order barring photography of this witness. And I don't think there was mention about to what extent. If the parties don't want to mention the witness's name in open court, I mean, that's their prerogative. No one can compel them to talk about that. But I just don't believe there's a basis for the relief that Mr. O'Mara is seeking on the record before you. And that's all I have, Your Honor.
Okay, thank you. Mr. De La Ronda? Mr. Guy?
Good morning, Your Honor. Judge, we would ask that you deny the defendant's motion. We are all appreciate and understand the scrutiny that this case has drawn. However, we have gone to great measures, as the court knows, to protect the privacy of these witnesses. The state's concern is this. What is the jury to think if we were to mask or erect a screen up for a particular witness? That, would, to me, would be alarming and confusing to a juror and might otherwise highlight their testimony when it shouldn't be highlighted. Also, I think as we've discussed before, that the very content of their testimony, I think, would reveal in some respect their identity. For example, their address or their perspective from their residence of the events of that evening. So for that reason, we would ask the court to deny the motion. Also, we do not concede that these three persons referenced are critical witnesses. We believe every witness we're going to call is critical. So again, it unnaturally highlights the testimony of that witness, which we feel like would prejudice the jury and also may limit the state from inquiring of the witness about their perspective to the events that evening. So for those reasons, we'd ask you to deny the motion.
Just very briefly, before the court makes the final decision, I think in order to understand the gravity that the witnesses place on this concern, that you hold an in-camera hearing outside the presence of the media to maintain their anonymity to the extent of allowing them to testify truthfully to you what their concerns are, because though they're represented by counsel, I think that we need to give a three-dimension to their concerns before.
Their concerns fall in one of the categories as set forth in the case law?
You want me to give you my understanding of their concerns?
You said it for hearing today.
Okay, I'll give you my understanding. My understanding is that they are very concerned that when they come before the court and they testify truthfully as to what they saw, and if it leads to a certain verdict, let's say an acquittal, that they will be subject to ridicule or retribution because this case is already identified and has brought out an enormous amount of anger on both sides of the situation, and that these witnesses have said they are very concerned to the extent of possibly having to move out of their residence with what might happen if they come before this court and give information that leads towards an acquittal. Those are concerns that have been referenced. And though that's not in the Times matter yet, I'm not sure that we've dealt with many Zimmerman cases in our history yet, particularly not one that brings out so much animosity on a social issue and focuses it on a trial where an acquittal has suggested to be a loss for civil rights and a conviction something else. So their legitimate concerns are their personal concerns for their safety when they do what they're being required to do as a citizen witness, and that they're going to have an aftermath that they have to deal with, and we have an easy way to minimize it. Is it perfect? No. Does it evidence a sensitivity by this system to witnesses who have to give testimony under oath? Yes. So the balancing test, I think, should weigh in favor of those witnesses maintaining anonymity. Again, it's Mr. Zimmerman's right more than the media's right. So all I'm asking is to have an opportunity at this point for the witnesses to come before you in camera, and so that the court can question their concerns and see if they're in fact legitimate. Because I think you may find that they are.
Judge, I would just join in and ask that you reserve your ruling until you did have an opportunity to hear from the witnesses. And I think Mr. O'Mara made a great point that this is basically a case of first impression in regards to the totality of it, and perhaps there will be another category added to that list. So that's what I would ask.
At this time, the motion is denied. Is there any other reason, Mr. Ponce, that you want to participate in this here in the rest of the hearings?
No, ma'am. If there are no other media-related or access-related issues that are going to come up, I don't need to stay on.
Are there any other issues? I don't believe there are.
Just one, Your Honor, as to the names being released, that's still going to be under seal at this point?
It's under seal until we start the trial.
All right. Thank you, Your Honor.
Okay, thank you. Thank you.
To that point, Your Honor, real quickly, under seal, the only thing under seal is the public records were held exempt.
Right.
I'm not sure if that's what counsel meant.
I think that Zimmerman is under the prior court order that
Yes, ma'am.
Had been listed by a witness number that will remain in effect until the start of the trial.
Okay, thank you, Your Honor.
Okay, thank you.
And Judge,
You're welcome.
just for clarification, did you want me to file a separate pleading under seal, or did you want me to literally give the names to the clerk on just a written piece of paper?
You could give the names to me on a written piece
Okay.
of paper.
All right, I'll do that right now, Your Honor.
Okay, thank you. All right.
Thank you, Your Honor.
Okay, bye. Thank you, Ms. Speaker. Okay, I don't know what you had arranged with the witnesses as to what time they were going to be here, so
Certainly. We have the continuation of the motion for sanctions against the state attorney's office. I
was concerned about the expert witnesses.
Yes.
Set them for a certain time.
We have them sort of on hold, as I presume the state does as well. Mr. Manti, I think, is coordinating those. We are hopeful that the presentation to the court by video conferencing is going to be flawless. We may take a break. Yeah, as best it can be. So we have that.
All right, so the next one that we'll do is the motion for sanctions that we had begun last time we met. So if you want to go ahead and proceed, call your first witness.
I have my next witness to call, Your Honor, if I might have a moment.
Your Honor, if I may, I believe we were not done with Mr. White. I didn't have an opportunity to cross-examine Mr. White.
We
Present him first, then.
Pardon?
We'll present him first.
Okay.
As the witness is entering, just so we're clear, I had prepared to present the other witness now that we had the information which was necessary as a foundation for Mr. White as we got that information. So I understand the state's normal ability to cross-examine, but my understanding, just so the court is clear, that we were setting that as a foundation for the actual witness to testify. So,
Well, we had a witness on the stand
Sure.
in the middle of the hearing who decided to continue it, so
Yes,
we're
ma'am.
going to go ahead and move forward with Mr. White. Yes,
I believe that he's being gathered at this point.
yes.
Would you like to have sworn? Do solemnly swear or affirm that your testimony is pursuant to the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do. So I got it.
Thank you.
Morning, sir. State your name, please.
My name is Wesley White.
And you recall being here last week testifying concerning a matter regarding sanctions against the state attorney's office.
Yes, sir, I do.
And at that point, you had identified a client of yours who was or is an employee with the state attorney's office, correct?
That's correct.
And have you brought him here today for testimony?
He's waiting outside.
Thank you. Mr. President.
May it please the court? Mr. White, the person you talked about, Mr. Krybos, he is a friend of yours, is that correct?
Yes.
Okay, and how long has he been a friend of yours, sir?
We object, Your Honor, on grounds of relevance.
Your Honor, this is to show bias.
As to, I would ask, rather than general bias, that it be specific to something the court should consider as to whether or not this witness, who is limited just to identify communications he had with a client.
In my courtroom, this is for all of you. I don't want to speak to objections, particularly during trial. So your objection is relevance, he said bias.
Let me correct that answer. We're not social friends, but I consider us friends. Sort of like you, Mr. Del Ronda.
You were friends, you are and were friends with Mr. Krybos, is that correct?
That's correct.
All right.
But not social friends.
Okay, so you have never had him over to your house?
No, never.
And he's
well,
never-
actually, he was over and saw my daughter and helped her with a computer problem at one time.
Okay. My point is, even though he worked and is currently still working at the state attorney's office, you knew him also on a social basis, too?
No, that's not correct.
You did not?
I've never had dinner with him. I've never had lunch with him. I've never shared a beer with him. And to me, that constitutes a social basis.
He also lives in Nassau County where you live, does he not?
That's correct.
Okay. Talk about your employment with the state attorney's office. You were employed at the state attorney's office for almost
Again,
a
Your
decade.
Honor, if I might object on grounds of relevance.
This is to show bias, Your Honor, as to his reason for coming.
In 2009 through December 2012.
Either, did you?
Well, I would disagree with that.
Your Honor, objection. I don't want to just keep doing it, but on grounds of relevance as to his prior trial experience.
The relevance is, I'm going to hopefully establish, Your Honor, if I may, in terms of his bias. I guess to answer the court's. Thank you, Your Honor. Prior criminal trial experience, correct?
No, that's not correct.
How many prior trials had you done prior to coming to the state attorney's office?
How many criminal trials?
Yes, sir.
2.
Okay.
I believe 2. May have been more.
All right. And how long have you been an attorney?
33 years.
Okay. And you helped out Ms. Corey in her campaign where she ran in 2007, 2008. Is that correct?
I did.
There was a change of division chiefs in terms of actually handling the cases day to day. Is that correct?
Yes.
Okay. Isn't it true?
Understand your question.
I'll be glad to rephrase it, sir, so you can understand it. you not make inappropriate comments to certain employees of the office and result in a lawsuit against the office?
Let me object, Your Honor. Relevance and it's not before the court.
The answer is no. Actually, a lawsuit was brought against the state attorney's office as a result of a wrongful termination alleged to have occurred by Cheryl Peak, Angela Corey, and Dan McCarthy. I was not named as a defendant in that lawsuit.
You're well aware of
Yes, sir.
Okay. You also
We're speaking very expansively.
Sheriff Seagraves.
Yes, I had problems with Sheriff Seagraves.
Now, isn't it true that when you were employed also there at the state attorney's office in Nassau, running that office, that Mr. Guy and I had to
It's before I came to work at the state attorney's office. In my understanding, it was assigned to you before I ever came to the state attorney's office.
Okay.
Conviction of Ms. Corey's tenure in office, and that was a case that had been mistried by Doc Burgess, a former county court judge and former prosecutor before me.
Did you do that trial?
I did that trial with Bobby Lippelman, yes, sir.
Okay, and how much of the trial did you actually do?
I gave the opening, I gave the closing, and I did most of the cross.
Okay, so that would be your first murder case?
That was my first murder case.
Okay. All right, let's not dwell on the matters. My point is, at some point, your performance in the office was an issue, was it not?
Not to my understanding.
Okay. Wasn't your performance lacking? Specifically, in November of 2012, weren't you brought to the office, and did I, not myself, Ms. Corey and Ms. Peak, have a conversation with you regarding the performance or lack thereof of the office that you were managing?
That's an absolute misstatement of fact.
Did you not ask Ms. Corey specifically, in my presence and Ms. Peak's presence, that if she could give you another 6 months to get that in order in terms of the problems you were having in Nassau County?
That's not correct.
What, you didn't say anything about another 6 months?
I did say 6 months, but you'll recall that we had a sheriff that we had a problematic relationship with, and I'm talking about the entire state attorney's office. We had a new sheriff, and I felt that this new sheriff would bring more cases, and the issue was, according to you, sir, that we weren't trying enough cases or we didn't have enough caseload in Nassau County.
Being demoted, that you were going to get a cut in pay, and that you were going to be transferred to the Special Prosecution Unit and to report to. You were never told that?
Sir, I wasn't told what you have just stated in your question.
You were not told that your salary was going to be decreased?
I was told that, yes, sir.
Okay. So let's break it down because.
Please.
You were told that your salary was going to be decreased, correct?
That's correct.
Okay. And you were also told that you were given an option that you no longer were going to be in charge of the Nassau County office. Is that not true?
That's correct.
Okay. And you were told that your option was to come to the state attorney's office in Duval County and to work economic crime cases or white-collar crime cases.
That's my understanding.
Okay. And you were to report to a director, Mr. Manti.
I wasn't told that, sir.
Okay. So that's the part that you forgot.
Well, that's at least one of them.
Okay. And so your position of authority over Nassau County was no longer going to be in effect, in other words.
My understanding and what I was told was because of budgetary concerns, the director's position in Nassau County was being terminated.
Because of budgetary concerns?
Did you not hear me, sir? Yes, budgetary concerns.
So it wasn't because of your performance?
No, sir.
It wasn't due to the fact that you were only carrying a caseload of 2, while other directors in the office were carrying caseloads of 15, 20 cases?
As far as I know, no, sir. And I don't agree with those figures either.
You don't agree with those figures?
No, sir, I do not.
Okay. You remember me sending you an email regarding the performance in Nassau County?
No, sir.
You never received a...
I don't recall receiving any email from you complaining about or bringing up my performance as an issue.
Okay. Let me see if I can refresh your memory, sir.
Pardon me?
Let me see if I can refresh your memory. Back on November 15th, let me...
If there's an opportunity, yeah, I'd like to see it if I might.
I'll be glad to.
Thank you.
You're welcome. If I may approach you. You recall that I sent you an email on November 15, 2012?
I don't recall receiving that email, sir.
You don't recall the email stating?
I don't recall receiving that email, sir.
Well, do you recall how many cases you had in Nassau County that you were actually handling yourself?
I was involved with all my attorneys on all their cases, tried most of the cases with them, and was doing a significant amount of work in those cases.
Don Carter, who is mentioned in that email, she was in charge of what in the office there, sir?
She was a unit supervisor.
And isn't it true that on this email it states Laura Coggin had a caseload of 95, Beverly Collins 79, John Kalinowski 2, Donna Thurston 27, and you had 2?
That's what that document says. I don't recall receiving that document.
You dispute that you only were having actually 2 cases?
Yes, I do.
Can you name the cases that you yourself were handling yourself?
Not at this time, no.
Okay.
Do you want to give that to the clerk and then mark it as
Yeah, sure. Now, you do recall meeting with me and Ms. Peek and Ms. Corey, correct?
I do.
Okay. Thank you. I'm sorry. Did you need to see it again?
Only if you're considering attempting to admit it, but it's just being marked for
identification.
Yes, thank you.
And in that meeting, we had discussions about your performance, did we not?
No, sir, not my recollection.
Okay. So this was just a meeting to say, Wes, you're doing a great job in Nassau County, and we wish you stay with us for another 4 years.
Well, I was invited to stay another 4 years. It included many subjects, including the Trayvon Martin case.
You were asked to take over the Trayvon Martin case?
No, sir, I was not. I was castigated by Ms. Corey for my hand or my involvement, that she believed, in bringing that case to her circuit.
Well, since you mentioned the Trayvon Martin case, George Zimmerman case, isn't it true that you wanted to handle the Trayvon Martin, this George Zimmerman case because you wanted the publicity?
I wanted to handle every single case that came to my office.
Okay. Well, let's see if we can keep on track, sir. You ended up, after the meeting with Ms. Corey and myself and Ms. Peek, where you were given an opportunity to be demoted in terms of salary and being sent to Duval County. You declined that. Is that not true?
Not immediately, no, sir.
How long after did you decline that, sir?
Well, I think you received an email from me a day or two later saying that I declined and did not wish to be reappointed to another term with Ms. Corey.
In fact, you're December the 5th. Does that sound about right?
I don't recall the exact date.
Where you specifically state, Dear Angela, formal and appropriate letter will be...
object, Your Honor. That's just improper use of a document.
If you'll show it to counsel first, and then show it to counsel first, and then show it to...
Thanks. My concern is more, it is an improper use of a document in examination of a witness, but I've seen it.
I wanted to make sure you saw it before
Thank
you
you.
showed it to the witness, before we proceed further.
Certainly, and normally, Your Honor, my objection is that if in fact he's going to testify or have him testify from it, rather, I'm trying not to speak.
It's not going to be read into evidence at this time.
Generally speaking, He has to not have a current memory of what happened before a document is used to refresh his recollection. Okay. Thank you.
Yes, sir.
Okay. Do you recall that now, sir?
Yes, I do.
Okay. And do you recall that document, and we'll label it, if we could, Your Honor, State's Exhibit B for identification?
We can mark the State's Exhibit B for identification.
Do you recall the bottom part of that document as the email that you sent to Ms. Corey?
Well, I recall my email, which says Dear Angela, and I recall it in its entirety. Yes, sir.
Yes, sir. And do you recall the top part of that document, my response to you? And if I may, Mr. West.
Take a look. Yes, the portion which said Ms. Corey would like to present a plaque to you at our annual office awards luncheon. Yes, sir, I do recall that.
Well, if you're going to read part of it, let's go ahead and read the whole thing so there's a complete record of the response. I guess I am, since he's read part of it, Your Honor.
Is there any objections?
There is improper foundation at this point.
He's identified the exhibit as something that he wrote and received, so it will come into evidence for the purpose of this hearing as State's Exhibit number 1.
Now that it's in evidence, would there be a copy available, possibly? Or...
Sure.
Great,
I'll
thank you.
for you. If we could, sirs, do it chronologically, State's Exhibit number 1, if you could first read your email to Ms. Corey.
Dear Angela, a formal and appropriate letter will be forthcoming, but I didn't want to leave you or Rich in a lurch as to Friday. With respect to the Morganty meeting, you may wish to have another ASA or outside counsel appear in my stead. I no longer seek or will accept reappointment to the office of the State Attorney for your second term. Given the few days left of my service, realistically, I would not be able to effectively pursue any matters with the City of Jacksonville. I will work diligently to clear pending matters on my desk, and as always, I'm grateful for having had the opportunity to serve the fine people of Nassau County.
And do you recall my response to you, sir? That's on the top of that document.
Yes, sir, I do. Shall I read that as well?
Please.
Wes, inasmuch as Ms. Corey is out for a funeral, I am responding on her behalf to your email below. She accepts your resignation and looks forward to having a continuing professional working relationship with you. For planning purposes, we need to announce your departure from the State Attorney's Office and immediately begin planning for staffing needs created by your intention to move in a new direction in your career. Please forward your supplemental resignation letter at your earliest opportunity so that we can continue to move forward and make a seamless transition. I will get with you tomorrow to get the details about coverage needed in Nassau County between now and January 8, 2013. Ms. Corey would like to present a plaque to you at our annual office award. Most of us, we appreciate your efforts in Nassau over the past 4 years.
Do you recall those as being two accurate emails? Is that correct?
I have no reason to believe that they're not accurate.
You, in fact, did not tender a formal resignation letter to Ms. Corey, did you?
I sent an email later on in the week.
You sent an email not to Ms. Corey but to the whole office, did you not?
I did, but I also copied Ms. Corey, I believe.
Obviously, she works at the office. She's the boss, so she would be included in that.
Right.
Do you not agree? And do you recall the nature, the tone of that email?
Well, I imagine it was somber. A good friend of mine and our county court judge had passed the day before, and that day I sent off a notice to the entire office that Judge Burgess had died, and I also sent a notice that I would be leaving the office of the state attorney.
Do you recall anything else in the nature of that email that you sent?
I think I thanked law enforcement, and I thanked the people, the very good people that I've worked with, and I can't recall beyond that.
Did you make anything negative comments regarding Ms. Corey or her office?
I don't recall. Oh, yes. Yes, I did. It wasn't negative. It was a statement of fact that when she ran for office, she had promised that and this was a campaign promise made in Clay and Nassau counties, that she would have a local attorney managing that office. And I reminded her of that, and I told her that people would remember her more for the promises that she kept than her wins and losses.
Okay. And isn't it true, sir, that what we did is actually sent 2 attorneys that actually had, I want to say at least, 30 years or 60 years combined experience more than you did in criminal matters?
They weren't from Nassau County, and they didn't even know which way the roads ran.
Did they have more trial and criminal law experience?
Yes, sir, they did.
Both of them did.
Yes,
That's
sir.
not true. That is the division chief, Ms. Donna Thurston, and the senior division chief, Mr. Steve.
The streets run in Nassau County. They don't know the difference between a pulp mill and a pogey plant.
Some congratulatory emails, did you not, sir?
Pardon me?
Did you send me some congratulatory or congratulations emails?
I hope so.
Okay. And also, Mr. Guy, in terms of when he was appointed senior director?
I hope so, yes.
All right. So your issue in this case is you felt you had to come forward because you had some information. Is that it?
I'm an officer of the court, as you are, sir, and if I believe or if I come to understand that misconduct may have occurred, that you or any attorney may have misrepresented something to the court or had otherwise confounded the process that we live by, that I have an obligation to look into it, and that's what I did.
Okay. And this came to your attention through Mr. Krybos?
That's correct.
Okay. And he came to you as a friend, correct?
He came to me seeking legal advice as an attorney.
So he hired you as an attorney?
That's correct.
Okay. And the payment on that is how much, sir? How much?
I haven't charged him yet.
Okay. And when was that exactly that he came to you seeking your advice as an attorney?
Approximately 6 weeks ago.
And when was that exactly?
I don't recall exactly.
I think last time, and I may be incorrect, did you say 5 weeks ago or you say now 6 weeks? And I may have that
Well,
wrong.
if I said 5 weeks ago, it'd be a week later, so now it would be
So
6
it was
weeks.
6 weeks.
So approximately.
I want to make sure it's accurate. You're thinking sometime when?
I don't have a precise date, sir.
Okay. Did you log him in as a client anywhere in your files or anything?
No, sir, I did not.
You did not open a file regarding him?
I maintain my files on my computer with regard to notes that I take and subjects that I need to be looking into.
Okay. And so he came to you out of the blue, or did he call you ahead of time?
I don't recall.
Okay. And you met with him where, sir?
I don't recall that either. It might have been Chili's. It might have been.
Was it a restaurant of some type?
I don't recall.
Well, did you go to the state attorney's office and meet with him there?
No, sir, I did not.
Okay. Did you meet him at your office?
I don't have an office at present.
Okay. Did you meet him at your house?
I don't recall. I don't believe so, but I don't recall.
Okay. Was he on the clock? Was he working as an employee of the state attorney's office when he met you, sir?
I don't recall the specific time.
Do you recall what time you met him? Was it at daytime or was it at nighttime or was it, with him?
No.
Okay. You said you made a note of it in your computer?
That's how I would typically deal with any client matter. I would make notes in the computer and also a list of things that I needed to do.
Yes, sir. And do you have that in front of you, sir?
Pardon me?
Did you bring that with you?
No, sir, I did not.
You don't have any type of iPad or anything?
No, sir, I do not.
You don't have any kind of phone or anything where you can look that up?
I have a phone, but I don't have the capability to look it up here.
Okay. So you met with him and he told you he was concerned about something, is that correct?
That's correct.
Okay. And what exactly did Mr. Krybos tell you?
Your Honor, he's well capable of making an attorney-client objection. I just want to make sure that it's clear that I'm not waiving something because if in fact that's why I'm doing it hesitatingly. But I'm concerned that it is not proper.
Concern is not an objection.
Okay, then I'm going to sit down.
He came and told you something, correct?
Well, with respect to this matter, he was concerned about whether he had any kind of criminal exposure as a result of actions or possible actions by you, sir.
Okay. And so he specifically told you that he was concerned about a criminal matter.
I've given you an accurate representation of what he said.
Those were his words, not yours, is what I'm getting at.
Pardon me?
Those are his words exactly, not yours.
No, they weren't his words exactly.
Well, what were his words exactly?
I don't recall his words exactly.
Did you make any notation anywhere of what he said?
Not that I recall here.
Not that you recall here, or not that you recall at the time?
Not that I recall now. At this point in time, I don't recall if I made notes with respect to the specific words that he used.
Okay. Well, at some point, did you meet with Mr. Romero, Mr. West, or somebody to let them know about
Did.
How did Mr. Romero become aware that you knew that, sir?
I asked him if he had received photographs and some deleted text messages, and I gave him an understanding of what those photographs were.
Okay. And when did you call Mr. Romero's office?
Shortly after I was retained by Mr. Kryboss.
And when would that have been? On the internet or something? How did you know his phone number?
I don't recall.
You had prior meetings with Mr. Romero about this case?
I've never had.
For a secretary, a paralegal, an intern, Mr. West, anybody else? I'm just trying to get this.
I've never met anyone in his firm before my appearance in court last week and seeing these folks here today.
Okay. And had you spoken to anybody?
As well.
So this was like a conference call?
Well, a conference call and that more than two people were involved? Yes.
My question is, was Mr. West in his office, or did you arrange for Mr. West and Mr. Romero to be together when you spoke to them?
I didn't arrange for anything, and I don't know where he was.
So you happened to just call Mr. Romero's office and Mr. West was there and you spoke to both of them at the same time as your testimony?
I don't recall exactly how the transaction occurred.
My question is that you call him ahead of time and say, listen, I need to talk to you about something, and Mr. Romero said, hold on, I need to get Mr. West involved, or is it just a coincidence that Mr. West happened to be there at the time you called?
Well, I think there was more than one conversation with their office,
okay.
And I think the initial conversation was just with Mr. Romero. I told him that I understood that there were 3 photographs and deleted text messages that he may have not received, and I wanted to find out whether he had received them or not.
Okay. And did you identify the 3 photographs?
As best I could. My description was very vague. It was and deleted text messages involving either the purchase or sale of a firearm.
Regarding the what? I apologize.
Purchase and sale of a firearm.
Okay. And you told that to Mr. Romero?
They did not receive that information from the state.
Okay. And you told them that they had not received it?
No, they told me they had not received it from the state.
So you first inquired as to whether they received it or not?
That's correct.
Okay. Why did you feel a need to call Mr. Romero to inquire whether they had received that or not?
Because I'm an officer of the court, and I believe that it's incumbent upon me to find out whether you had provided certain information, which I think is your obligation under the reciprocal discovery requirements of the Florida Rules of Criminal Procedure.
How did you know that it had not been given?
I don't know whether it had been or had not been. All I know is Mr. Romero said that it had not been.
Okay.
I have no independent knowledge whether it had been provided or not.
You have not examined the bin file or the dump file from the victim's cell phone?
I have not looked at anything. I have not received the actual photographs, the deleted text messages, or any material at any time.
So you have no independent knowledge whether that was turned over or not. You were just inquiring whether it had been.
That's correct.
Is that fair?
That's correct.
Okay. And did you ask him about anything else, whether anything else had been turned over?
Did I ask about anything else? No, sir, I did not.
So you only focus on those 3 items, right?
Those are the only things I was aware of. 3 photographs and the deleted text messages. And I believe the photographs were deleted photographs as well. But I'm not certain.
I don't understand what you said.
I think they were recovered photographs, like recovered deleted text messages, but I'm not certain. The text messages, I believe they were deleted, but the photographs, I don't know.
Okay. And after the second conversation, what did Mr. O'Mara or Mr. West or anybody else in that firm tell you?
That they had not received it.
Did they tell you anything else?
I think that was, I can't recall anything else.
Okay. And then you just need to appear last time we were in court on April 30th or whatever day we were?
They subpoenaed me.
Okay. So
they did ask me the identity of my client, and I refused to give it.
Okay. You already had disclosed what your client told you, right?
I disclosed that that information was out there. Yes, sir.
Okay. And so I'm assuming you had some kind of agreement with, now we know the client is Mr. Kreidboss, that you could disclose that, correct?
Yes.
I mean, he had agreed that there would be no attorney-client privilege.
As to that limited subject, when I explained my obligations as an officer of the court, he agreed.
Okay. And it was your understanding that these items you suspected had not been turned over to the defense. Is that correct?
I had no suspicion whether they had been or not. I just felt I was obligated to find out whether they had been or not.
Okay. So the bottom line is you don't know whether they were or not.
I have no idea, sir.
Okay. But you felt the need to inform
inquire.
Okay. And then you showed up in court, right? You were subpoenaed.
I was subpoenaed, sir. Yes, sir.
And when did you receive that subpoena?
I don't recall.
Was it like the day before or a week before?
Prior to my appearance. I don't recall when it was.
Okay. And how were you served?
By email.
Okay. You never felt the need to inform the state or anybody else about that?
I assumed that counsel would do that, or you would find out through looking through the court file. But no, I did not.
You assumed that defense counsel would inform the state that you were going to be listed as a witness? Or?
I just assumed that it would be listed somewhere.
Okay. Would you be surprised that you were never listed?
I don't know that if I was listed or not. All I can do is take your representation that I wasn't listed or that you weren't informed.
Okay. Well, did you tell Mr. O'Mara, hey, listen, you need to let the state know, maybe I'm wrong. Maybe that stuff was turned over.
That's a question that has multiple parts to it. And if you want to break it
You're a
apart,
lawyer. I'm trying to make it. I'll break it down for you if you want.
Please.
Okay. My question is, when you inquired to Mr. O'Mara, and did you say, listen, are you going to let the state know? Maybe I'm wrong. Maybe my client's wrong. Maybe that stuff was turned over.
No, what I told Mr. O'Mara is I had no independent knowledge whether or not these documents had been provided, and that's just a question to find out whether they had been or not.
Now, in your discussions with Mr. Kreidboss, did you also discuss with him his tenure at the office at the time, whether there were suspicions of something he had been involved in or not been involved in?
I don't recall any such discussions.
You did not have any discussions?
Sir, I don't recall any such discussions.
So that means you did not have those discussions with
That
him?
means I don't recall them, and it means also if there are discussions that are outside the parameters of the issue that are here today, I will assert the attorney-client privilege.
I understand. My question is, don't you think those are relevant as to establish bias on the part of Mr. Kreidboss as to why he might come forward and make such an allegation?
I wasn't concerned about his bias or not. I was concerned about whether or not you had fulfilled your obligations to this court.
Well, you've been a lawyer for how long, Mr. West?
You've asked that question before. It's 33 years, sir.
Wouldn't you, when somebody comes forward, wouldn't you automatically say, okay, hold on, what's your reason for coming forward? You've been working for the state attorney's office for so long. Wouldn't you inquire as to what his motivation or bias would be?
No.
You didn't have any such discussion with Mr. Kreidboss at all?
No.
Okay. So now you do have a recollection, and you did not have such a discussion with him?
I don't recall any such conversation.
Okay.
But again, it would be covered by attorney-client privilege if I had. He may have a better recollection than I have.
I'm just trying to get your take on it of what, because he's testifying, so
Good.
I can call him. I guess I call you after. You don't have an independent recollection at this time.
I don't.
Okay. And before you left the office, or at some point, did Mr. Kreidboss, was he involved in doing something with your computers at all? Do you remember?
My understanding is he picked up my computers, and it's my understanding that he picked up my computers, or the IT department picked up my computers, and they'd be recycled to somebody else.
You know why they were wiped clean?
I assume that was in preparation for the next user.
Okay. So,
And I don't know, in fact, that they were wiped clean.
okay. And also, by the way, have you been blogging about this case at all?
No, I have not.
You've never used the blog Little Rio?
No.
What have you blogged on this case?
My blog is Jesse Jacksonville, and it specifies my name, Wes White.
Okay, so you don't do an anonymous blog?
I don't do any anonymous blogging, sir.
Were you aware of a Little Rio being blogged?
I saw one in an article today that, came out last night. I have no idea who it is.
And in that article you were quoted, correct?
Pardon me?
In that article you were quoted, were you not?
Yes, I was.
Okay. You've taken this as an opportunity to, because you want to run it.
In that regard, but I'm here today because of my obligations to this court as an officer of the court.
At some point, you felt you should have been state attorney in West Palm Beach. Isn't that true?
I applied for a vacancy of 8 to 10 months, I believe it was, for a position in Palm Beach County that was open.
And you were turned down by the governor. Isn't that true?
I was not selected by the governor. That's correct.
Okay. Now, in your discussions with Mr. Kreidboss, did he tell you about his position having changed in the office in terms of his?
I'm sorry.
I'm sorry. I'll be glad to rephrase it. In your discussions with Mr. Kreidboss, when he came to you to report this, did you have discussions with him about his tenure in the office and how it had changed in some ways?
I don't recall any such discussions. But again, that would be covered by attorney-client privilege. My focus was based on, again, my obligations. As soon as I heard this, my obligations and what I was required to do, my ethical constraints. And my ethical constraints were to go to this judge or through opposing counsel or find out whether you had complied with your requirements under the law. That's what my focus was. Otherwise, I would have been more than happy just to not be involved.
You didn't contact the judge, did you?
Pardon me?
You did not contact the judge, did you?
Did not do what to the judge?
Did not contact the judge.
I did not contact the judge.
You didn't contact the governor's office?
I did not contact the governor's
You
office.
didn't contact me and say, hey, is that true? What's going on?
No, I didn't contact you, sir.
You didn't contact Ms. Corey.
No, I did not.
And why is that?
That would be sort of like asking, well, let me put it this way, sir. If you've been engaged in misconduct, I think I would be the last person you would disclose that to. And if I could do it through a simple phone call with Mr. O'Mara, and if he could say, yes, we got those photographs, we wouldn't be here today. This wouldn't be an issue at all. But if I contacted you, I could not. If you had purposely misled this court, I don't expect that I would have gotten a straightforward answer from you. So that's why I didn't contact you.
It's not because of bias or anything, correct?
It has absolutely nothing to do with bias.
It's not because you were mad because basically you were told you were being demoted and you were no longer going to work at the state attorney's office other than in another position.
No.
Okay. So you didn't contact the judge who was presiding over this who would determine what was going on.
No.
Correct? But you did contact Mr. O'Mara.
That's correct.
Okay. And you felt that would be the appropriate way to do it.
I thought it was the quickest, simplest way to address an issue.
Even though you had no independent knowledge that actually had occurred.
That's correct.
Would it be fair to say that you're not a fan of the state attorney's office in the 4th Judicial Circuit?
I think there are an extraordinary amount of very talented people there. Very good lawyers.
Because of the way you departed or you were told that you had to depart or the way you resigned. I can't remember whether did you formally resign or not?
Well, I asked that I be kept on until the end of the term, but you interpreted that as being a resignation, so I think resignation is the operative word.
Okay, so you did resign officially.
Well, that's what you called it, so I'll accept it.
Okay. You weren't happy with that, correct?
I had mixed feelings about leaving the state attorney's office. I loved working for the people of the state of Florida, and particularly for the people of Nassau County. I loved being a minister of justice and making sure that this system that I've sworn my life to, my adult life to, is run according to the highest ethical standards available. I wouldn't trade it for anything. It was a wonderful opportunity to work for the state attorney's office. The circumstances of that opportunity changed, and so I was compelled to leave.
You were questioned about the performance of your office.
No, sir, that's not correct.
All right. Well, let me show you an email, and I'll show it first to
Thank you.
Mr. O'Mara. I'll be glad to give you another copy.
Okay, thanks.
Let me make sure it's the same one. Sorry. We could, Your Honor.
For identification.
Stage exhibit, or for identification, stage exhibit C. Maybe you misunderstood my question, Mr. White. Maybe that will refresh your memory. On behalf of Ms. Corey, I apologize. Read it for a moment.
Okay, your question, sir?
But my question was, does that refresh your memory in terms of, on behalf of Ms. Corey, we were setting up meetings to review the performance of everybody in the office, specifically all the areas?
No, I don't recall that email.
You never got this email?
I'm not saying that. I'm saying it doesn't refresh my recollection. I don't recall it.
Okay. Your Honor, then I would like to introduce it into evidence.
No, thank you.
For identification will come into evidence for this hearing as State's Exhibit number 2. What is the date of that email?
At the beginning, at the very top, it says November 30th, 2012. And Mr. White, at the bottom, it says November 29, 2012. I'll read it with you, so make sure I don't say anything correct. It says, Wes, are you available to meet with the boss and me next week? I was thinking Tuesday, but need to verify boss's schedule. Thanks, Bernie. And you recall a response on your part on November 29th at 5:43 p.m., certainly. And if an opportunity exists tomorrow, Friday, that would also work out well. Any subjects that I can prepare to address. And then I've responded, Wes, I'm out of the office today, so let's leave it for Tuesday. I'll check and see when the boss is free that day. As you know, Ms. Corey's first 4 years has resulted in dramatic improvements. The media doesn't like to give us credit, but the public certainly is aware of what we've done. Nevertheless, we can always enhance our performance. We're in the process of reviewing the performance of all areas of the office and making adjustments to make this an even more efficient and better place to work. We are meeting with the heads of all departments. And then you responded on November 30th at 7:02 a.m. Excellent, thanks. You don't recall that at all?
No, sir, I do not.
Do you have problems remembering things? Or do you have a vivid recollection of things?
I remember a lot of things, sir. I remember those things that I believe I need to remember.
Are you
but
disputing?
Pardon me.
I apologize.
I was going to say, after 33 years, you learn to sort of box off things that need to be remembered and others that sort of you can let go.
Unpleasant things you kind of want to put to the side.
No, not necessarily unpleasant things, sir.
Okay.
I remember you. I remember Mr. Guy. I remember many fine people at the state attorney's office. But if you asked me many of their names, I couldn't tell you because it's simply something I don't remember.
So since you mentioned my name and Mr. Guy, and you also in that same sentence, I think, maybe it wasn't intended, you said fine. Am I considered a fine individual or not?
I think...
Now, I object, Your Honor, on grounds of relevance.
Okay. But you don't remember the series of emails?
I don't remember that email, sir. No, sorry.
All right. Now, if I may have a moment, Your Honor. Finally, sir, you mentioned that you went to Mr. O'Mara because you felt potentially something had happened, correct?
That's correct.
Okay, so in your opinion, that would have been misconduct if it had occurred, potentially?
Yes, potentially, yes.
Did you report that to the Florida Bar or anybody else?
No, I reported it to counsel, and I left it to him to deal with it as he thought fit to bring it in front of the judge.
So the bottom line is you didn't think it rose to that level?
Well, I didn't know. All I had was his representation of that he had not received it. I didn't have those files. I did not have the panoply of discovery that had occurred throughout this trial to check and see. Had I done that and had I determined, I might have come to the court directly, but I didn't. So the quick way was to call Mr. O'Mara.
So you know, as a fellow lawyer, you have an obligation, if you're aware of misconduct by another lawyer, that you have an obligation to report it to the Florida Bar. Well,
I think what we're here today to do, sir, is to determine whether there was misconduct. And if the judge doesn't refer to the Florida Bar, well, then I guess, according to you, maybe I should.
Well, didn't you make a comment after the last hearing where you were here in court and you made a comment about myself, Bernie De La Riona, that you were saddened by what I did?
Yes, I did.
Okay, well, do you want to take that back now since you're unsure of what exactly happened?
No, I think that quote was not exactly. The question was, the predicate was, if this happened, would you be surprised? And I said, I wouldn't be surprised, but I would be saddened.
Okay. Wouldn't you agree that assumptions, we shouldn't rely on them? We should rely on facts?
Well, you know what assume stands for, don't you?
What?
Make an ass out of you and me. So, yes, I generally agree with that.
Okay. Thank you, sir.
Oh, yes, a couple of questions. Was that last exhibit put into evidence?
No.
Now retrieved from the clerk?
Yeah. I believe it was. Oh, I'm sorry, it was. It's in evidence.
Good morning, sir.
Good morning.
So, tell us specifically, as Mr. De La Riona asked you, why you felt it was necessary to inquire of someone, turned out to be me, regarding potential misconduct.
If a report was generated by the state attorney's office and it was preceded by another report from the Florida Department of Law Enforcement that was incorrect, and unless that correct report was provided, I think there's a misleading nature to that transaction, and also I think reciprocal discovery requires that that report be provided.
And you took the option of contacting me, correct?
That's correct.
And what did I tell you about whether or not we had received the documents that you were concerned about, whether or not we had received those from the state attorney's office?
You told me that you had not received them from the state attorney's office.
Did I evidence in that conversation other concerns to you regarding ongoing discovery issues that I had with the state attorney's office?
I don't recall.
Did I at that point then ask you who the person was who gave you that information?
Yes, you did.
I think you testified that you maintained that in confidence, correct?
That's correct. I refused to give it to you.
Mr. De La Riona has spent some time questioning you to suggest that you did this, that you called me and put these in motions because you have a bias against the state attorney's office. Do you recall those questions?
Yes, sir, I do.
And he spent some time talking about why you left the state attorney's office.
That's correct.
Did you leave the state attorney's office in such a way that you felt that you wanted to get back at them in some form or fashion?
No, not at all.
How long ago did you leave the state attorney's office?
December of 2012.
In the intervening 17 or 18 months, have you...
excuse me, that would be 7
or 8 months, I'm sorry. In the intervening 7 or 8 months, have you written any editorials or letters to the editors castigating the state attorney's office for their actions?
I have not.
Have you written any blogs attacking the state attorney's office?
I have not.
Have you written any letters to anyone attacking Miss Corey as being the state attorney's up there in the fourth?
I don't believe so.
Have you done anything to suggest that you are biased against the state attorney's office such that you would create a controversy that doesn't otherwise exist?
No, sir.
Mr. Delarianda had you review what is now an Exhibit 1, which suggests to be your initial resignation. Correct?
That's correct.
Have you had a chance to review it enough so I don't need to show it
I
to you
recall
again?
it, yes, sir.
Okay. Do you believe that there's anything within the context of that letter that suggests bias?
No, to the contrary, I express my gratitude to Ms. Corey for the opportunity to serve the people of Nassau County. And I'll express it to her again today.
The response to Mr. Delarianda, again, you've had a chance to review it.
Yes.
Does that response to Mr. Delarianda to your decision to not seek further employment with the state attorney's office, does that indicate any animosity towards you?
Well, I don't see it in there.
Any concern even with how you had performed your duties?
No.
Any issue whatsoever which may have suggested that there was animosity between you and Mr. Delarianda?
No, not
How
that I
about
see.
you and anybody in the state attorney's office?
I didn't interpret it that way, no, sir.
He has made a concern and suggests that it's bias that you only had 2 cases that you were covering in Nassau County. Was that a concern within the office at the time you were employed there?
The concern that I recall was that we didn't have enough cases because the sheriff's office was not bringing enough cases to our office. And my response was, wait till the new sheriff starts in January, and I think you'll see things considerably pick up.
Is a lot of information flow back and forth in the state attorney's office by emails?
A lot is a subjective.
Okay.
We were generally encouraged not to put a whole lot of things in email.
Okay. Encouraged by whom?
By the management staff.
Did they give you any reason why you should not put information in emails?
I don't have a specific understanding of why, but it maybe perhaps has to do with the public records law, but I don't know.
Okay. Yet it seems there was information back and forth between you and Mr. Delarianda concerning your performance and Nassau County's performance, correct?
Well, again, I don't think it related to my performance. It related to the overall office's performance. And that was not really performance. It was more of a factor of the number of cases that we had.
Have you had an opportunity to review the state attorney's office internal email files, to review all of the emails that might exist, documenting information flow between you and Mr. Delarianda?
I have not.
Okay. Do you have access to that?
I do not.
Okay. For those that do have access to that, are there any other emails out there that would suggest, besides these, any concerns for your performance that might suggest bias in the email system of the state attorney's office?
Honestly, I don't recall any.
In addition to the questions I asked you a moment ago, have you had even conversations with other people where you have attacked the credibility of the state attorney's office in any form or fashion which would suggest that you're biased against them, such that you would make up this information that you're presenting to the court?
In no circumstances, with bias or without bias, would I make up any information presented to this court.
You had mentioned that you were contacted by your client and that he had a concern. What was his concern when he first contacted you?
His concern was whether he would face criminal exposure of some kind if the trial went forward and this material had not been provided to the defense.
And tell the court, if you would, of that conversation regarding his potential criminal exposure. What do you mean by that?
Well, he was very vague and really didn't understand that what his possible exposure might be, and it was hard for me to fashion a response because this is such a curious area in that it doesn't come up very often, and I think my response to him was possibly.
And when you told him that he might have criminal exposure, what was the act that he was concerned that either he had done or that he had not done which would lead to potential criminal exposure?
Well, that he had discovered information and discovered the report from the FDLE was incorrect, and that information had not found its way to the defense.
And was his concern that he, having known or being aware of that information, might also have criminal exposure if it wasn't uncovered and forwarded?
I think that's a fair characterization.
And did you advise him again that he might have such exposure?
I think the word was potentially or possibly.
And did that potentiality impact on your decision to come forward with this information?
Actually, no. My decision to come forward was based on the fact that I'm an officer of the court.
When Mr. Krudbos, is that the correct
pronunciation?
Krydbos, sorry, advised you that he had this information, was it limited to those sort of high points of the photographs and the one text message that you referenced in your earlier testimony?
That was all that he made reference to me about. So I don't know if they're high points or low points or mid points or whatever, but they were the 3 points that, or 4 points, the 3 photographs and the text messages that he relayed to me.
And was his concern to you then that he wasn't certain that that information had been turned over?
That's correct.
Then you called me, correct?
That's correct.
Advised me of that. And what did I advise you about how I would look into addressing that issue?
Counsel, I don't recall you telling me that you're going to look into it. My recollection is that you told me that you had not received those files, those photographs, those deleted text messages from the state of Florida.
Did we have a discussion about filing a motion to uncover this information by filing a motion for specific discovery regarding all of the reports on Trayvon Martin's phone?
I don't recall.
In subsequent conversations between you and I, have I advised you that I filed such a motion that was heard before this court several weeks ago?
I don't know if you advised me or if I found it on your website and read about it there. You
have an opportunity to look at the hearing, evidencing what Mr. Del Rionda's response to the court's inquiry in that regard was?
I recall the one at the end of April, yes, sir.
And what did Mr. Del Rionda say to the court in response to her inquiry as to whether or not he had received any other reports from any person, any source whatsoever since the previous report?
Counsel, honestly, I think that the court can remember what Mr. Del Rionda said, and also there's a videotape of it. My characterization is irrelevant. I would say that he was emphatic, that he said that he had provided all that he had, and I hope at the end of the day that that's correct.
Mr. Del Rionda had questioned you about the perspective of the state attorney's office of looking forward after the first 4 years of being even better in how they approach their work. Is that correct?
That's, I think, what he read to me. I don't. If that was an Exhibit A, yes. Otherwise, he just read something that sounded like that. So.
Is there anything that led you down the path, be it the fact that you applied for a West Palm Beach state attorney and didn't get it, or that you're no longer with the Fourth Circuit State Attorney's Office, or that you only had 2 cases, that led you down a path that you would create or cause to be created false evidence or testimony about what the state did or didn't do in their discovery obligations?
No, Mr. Mayor, the only thing that led me here was an oath that I took in 1979 when I became a member of the Florida Bar.
Thank you. Nothing further.
Very briefly, Your Honor. You recall having a conversation with Scott Hughes?
I've had many conversations with Scott Hughes, the last of which was at the funeral of his wife.
Yes, sir. Specifically, you recall having a conversation.
I would object, Your Honor. It's outside the scope of direct.
I don't know that yet until I hear the question.
Yes, Your Honor. It's just that the man, Scott Hughes, was never mentioned before.
But the contents of the conversation may have, so let me.
You recall having a conversation with Scott Hughes the week of March 10th of 2013, where he was at lunch with his dad at Callahan Barbecue?
I do remember seeing them at Callahan Barbecue, yes, sir.
Your Honor, that it's outside the scope.
I consider that to be a preliminary question to have this witness understand any question about the conversation.
Specifically, you recall telling Mr. Hughes, pardon my language, Angela would have rather kept me in the house pissing out than pissing in?
I don't recall saying that, sir.
And do you recall telling Mr. Hughes, maybe we'll be working together in 4 years?
Same objection. I don't know when to make it now, but it is outside the scope of direct.
Your objection about the last question is overruled. Let me hear the
The second question is, you recall telling Mr. Scott Hughes, who, by the way, is the chief investigator of the state attorney's office, correct?
Yes, sir.
Do you recall telling him that we will be working together in 4 years, meaning you will be in charge of the office in 4 years?
I don't recall that either.
Okay. You don't recall because you have a bad memory, or let's break it down. Did you have a meeting with Mr. Did you see him?
I didn't have a
barbecue?
meeting. We sat at the same table after I had lunch at another table, and we talked.
You expressed your condolences regarding the loss of his wife, correct?
Honestly, I don't remember if that was before or after the loss of his wife. I think it was after, but I'm not certain.
It was, but you expressed condolences regarding the loss of his wife.
Right.
Remember that? And you don't remember having a conversations where you used the words, I won't repeat them again, but regarding Angela, Miss Corey keeping you in versus keeping you out? You don't recall that at all?
No, sir, I do not.
And you don't recall stating to him that you would be working together, we, meaning you and Mr. Hughes, would be working together in 4 years?
I wouldn't have said that. I haven't made any decision about running against Angela Corey or running for that office or any office. So, no, I don't recall that.
Let's be honest here. Isn't this why this is all here? Because you want to draw attention to yourself regarding potentially running against Ms. Corey in 4 years?
That's absolute nonsense.
Okay. And finally, sir, did you turn over any evidence to Mr. O'Mara?
I have not turned over any evidence to Mr. O'Mara.
And as far as your knowledge, did Mr. Krybos turn over any evidence to Mr. O'Mara?
As far as I know, he has not turned over anything to Mr. O'Mara.
Do you have any idea how Mr. O'Mara would know and ask witnesses questioned in Miami when depositions were taken about a gun being mentioned in text?
I have no idea.
Thank you, sir.
I'm sorry, but thank you. The comment about whatever was just said, without repeating the vulgarity of it, was that a reference to an inquiry whether or not you were part of the source regarding information about upgrading retirement funds for Ms. Corey and Mr. Del Riondo?
I don't remember the conversation, so I can't speak to what it may or may not relate to.
Were you questioned by members of the state attorney's office regarding whether or not you had leaked information regarding putting more money in Ms. Corey's retirement fund and Mr. Del Riondo's?
I was not.
Were you aware of that issue happening, and were you questioned at all about how it may have come about?
Questioned by whom, sir?
By anyone in the state attorney's office?
No, sir.
Nothing further than your own.
Thank you. May Mr. White be excused?
Yes, Your Honor.
Mr. O'Mara, may Mr. White be excused?
Yes, thank you.
Thank you very much. You are excused,
Your Honor, with the court's permission, I want to.
No.
Your Honor, my client is entitled to a.
Time out.
Okay. We have a call saying right now you've been excused. If you have an issue as an attorney's license sending somebody, I'll hear you at that time.
Forgive me.
Okay, thank you.
I was going to just do what he tried to do from the witness stand, which is a relaxation of 9616 as far as the, hasn't been imposed yet, but the sequestration of witnesses to the extent that Mr. White is the attorney of record for the next witness.
If he wishes to remain in the courtroom during the testimony, he may do so.
Thank you.
Chosen to exit. Call your next witness.
Thank you very much. Would this be a time, Your Honor, maybe for a...
We're off the record, but
Sorry.
she's changing. Do you want to take a brief recess? Okay, we'll take a...
Yes.
Mr. De Obama, do you have some of the evidence?
Mr. O'Mara got the evidence back.
Don't leave the courtroom with it, please.
I think you were the last one.
Not
with
going
that
to be the
evidence.
last time it happens.
And it was unintentional, I think.
Oh, this is my
I
copy.
think that's your copy.
Did I give you the right ones back?
Yes.